Well, good morning, everybody. Lovely to have everyone here with me today for Does Your Estate Plan Need a Tune-Up? What a insanely interesting topic, Francisco. Yeah, I know. I try to bring the best to you guys, but I definitely want to say welcome. You guys are in the right place if this is what you signed up for. I see a lot of people who are current clients, past clients, people we know, but a lot of also a bunch of new friends on the list. So welcome everybody. My name is Francisco Servent. I am your presenter today, and a little bit about me, just so you know. I am the founder of Keystone Law Firm. We're a firm in Chandler, Arizona that does focus specifically on this kind of stuff. This is all we do day in and day out. We're helping people arrange their affairs, and we're helping people take care of somebody's affairs, a loved one, if they passed away. And sometimes that means we're going through the probate system to do that. It's sometimes not all organized as it should be, but you're here today to learn how to make sure it is, at least to the best as you can do it. And anywhere I can, I'm going to brag about my family on the screen. Hopefully you can see that. It is my wife, my 4 kids. Anywhere I can, I'm going to brag about them. Just love them to pieces, and I'm very just incredibly proud. I think we have the best kids in the world. My wife and I have been married for 20 years, and we really do. We just absolutely are amazed with our kids. So I want to make sure that I've got the technology set up real quick before we dive into the content. So if somebody would just shoot me a chat message and let me know we've got good audio, you've got the screen share, you can see the slides, and I just want to confirm that we are good with those things. Like I said before I dive in. All right, we've got one thumbs up. Excellent. We got great. Excellent. Okay, I think we are good to go. And then let me just make sure that I've got settings correct for others to join if they do arrive a little bit late. Okay, I think we're good to go. So, I mean, first, welcome. This is not a topic that everybody is so eager to even learn about, right? I mean, it's kind of just it's a taboo thing. None of us want to talk about our ultimate death or a loved one's death. It's a sad thing. But so I really just want to say good job for you for recognizing that this is something you're giving to your loved ones. This is something you need to learn about so you can do this for their benefit. We'll talk about some of the things that are for your benefit too, but really the fact that you're digging in, that you're doing this, that you're here today, really, I mean, I give you like a high five, because it's, like I said, it's not something, there are something like 14 or 15,000 brand new probate cases filed every single year, just in Arizona. 14,000. And for you few who are here, you've said, I don't really want that. I don't know maybe everything of what that is, but that sounds bad. I want my loved ones to be taken care of and not have to deal with that. This week I ran across an article, and this happens way more often than I am even aware of, but this one just struck me. A family was just cruising down the road in Phoenix this week or last week, and just bam, just completely T-boned in an intersection. Um, eight people involved in this car accident. 7 people injured. 1 person passed away. And I just, I look at those moments and think, holy cow, our life is just so fleeting. In just a minute, it, poof, it's over. And it's those things that just remind me how precious we have to take every single day. None of us are guaranteed tomorrow. That family, you know, um, that was not expected. There's obviously, that's not the only one. I think the statistics are like 3 people every day just in Arizona die in a car accident. obviously there's hundreds of people who pass away every day from other causes, and none of them are worse or better than the others. They're all bad, but it just hits me, that any moment, right? None of us have any guarantees. And we get so many of these phone calls that it just like, this is why we're here. This is why you're here, is because you have somebody you love that you care about. You don't want them to have some unexpected nightmare if that were to happen. We all know this is not a matter of if we're going to go, it's just a matter of when. So truly, truly welcome. Good for you for digging in and saying, I need to learn. I need to know what I need to know here. So when to update your estate plan? This is the whole thing, right? When do we update our estate plan? You got to protect your loved ones, but we know I've seen just too many families create their estate plan, and then a loved one passes away years later, and it's still a mess because it wasn't kept up to date. So that's the real topic of today. Before I go over the times and when you need to update, I just want to hit at least on 5 main documents everybody needs to have. We generally prepare 18 different documents as part of an initial kit. But these 5 are critical. So your durable financial power of attorney, that's the one that you designate someone to take care of your finances, pay your bills, keep things going in the money and the property sense, so that you're taken care of. And if you're married, your wife, your spouse, your husband is taken care of. That's the durable financial power of attorney. The second document is your health care power of attorney. Obviously, making medical decisions for you if you can't. Triggers for somebody else who you pick, right? You name somebody to make those medical decisions. If you're an emergency, it can either be, you were in a car accident, you're in a coma, or it could be that sort of long-term thing, which happens with like Alzheimer's or dementia, where there's a decline. And at some point it's, just, okay, finally somebody else needs to be able to go to the doctor's appointments, go to the hospital and talk to the doctors and be making decisions for you. That is where you designate them in that healthcare power of attorney. The third document is your advanced directive. In Arizona, we call that also a living will. This is where you say what you want in the event of the medical emergency, right? Keep me at home as long as possible. I don't want to go to a nursing home, or keep me on life support as long as possible, or, no, you can pull the plug, kind of a thing. It's all those decisions. What do you want? That goes in this document. Next is the last will and testament, really basic fundamental document. Just says who gets what you have after you pass away. And then it also designates your executor, who's going to be in charge of doing that. And then if you have minor kids, it'll also designate guardians for your minor kids to be able to raise them how you would want, hopefully. And then number 5, your personal property memorandum. Who's going to get the stuff? Who's going to get the items around the house? Maybe you've got jewelry, coin collection. Maybe you've got some antiques, artwork. And it doesn't have to be things that are necessarily dollar value, like high dollar value. It could be things, and this is just as important, things that have sentimental value, right? I mean, sometimes people will fight more over the sentimental stuff than they will over the dollar stuff. So I had one client who had a very unique ring that had been inherited by her. And guess what? She has 2 daughters. How do you decide? Well, the way you decide is infinitely better than not deciding at all, right? I mean, think about that. Wouldn't you rather have your 2 daughters mad at you for making a decision rather than mad at each other for the rest of their life? That's why estate planning is hard, right? We have to make the decisions. And sometimes people avoid making those decisions simply because they don't want people to be mad or upset at them. And I get that, but that's not who we are. That's not who you've been called to be. You are the kind of person who, as hard as it is, you've had to make decisions in life and live with them. And when you know it's a decision you have to make, that's what it is. So that's how these things play out. Okay, so how often, right? How often should you update your estate plan? If you if you've never done this, if you've never created a will or a trust, you're like, what am I? I'm in the wrong place. Let me just clue you in and to help you stick around here. What the value is you're going to get out of this is you're going to know that, hey, once I get this done, am I done? Am I done forever? Nope, you're not, right? It's like did you went to the gym once and you kind of got all pumped up and worked out a great workout. Are you done? I wish, right? No, like you did it once. Great job. You got to build that into your lifestyle and keep going in order to continue to be healthy. Your estate plan is kind of the same thing. And so what you'll learn if you've never done an estate plan, you'll learn today what you need to watch out for so that when you need to come back and make a tweak, it is necessary to keep these things up to date. So gulp it down, get it done the first time, but then know you need to be on watch for these things to be able to make changes in the future. And if you've never done it, my recommendation is you get started with something simple, easy, and learn from that. Do a little better the next time when you go back to make changes, and do a little better the next time, make some changes, maybe expand it, make it a little more sophisticated, maybe add one more feature, maybe add one more tax strategy or asset protection strategy. You don't have to start with everything. You can start small and build on it over time. So, but how often should you update your estate plan? There's no law that says how often. Okay. First off, let me just throw that out the window and make sure you guys aren't misled into thinking that there's some law that says it's every 5 years, it's every 10 years. There's not. This is something that we've just learned after doing this thousands of times over the last 15 years of how often it seems it is advisable and it ends up working well. It's like a personal trainer. There's no law that says you should work out every other day. No, just they're going to work with you and kind of craft a plan that says, okay, for your goals, you need to work out this much and do this kind of a thing. So for an estate plan, generally what we see is every 3 years. You don't want it to get older than that at all. That is a mistake waiting to happen. It's a nightmare waiting to happen. 3 years. What we do for our clients is we chase them down once a year and we do a really quick checkup. Hey, what about this? We got about 30 things we go through. And if nothing needs changed, great. We sign off and we say, you're good. The thing that sticks out in my mind was a client we called back after their first year, said, hey, anything new? No, nothing's new. Everything's the same since we did this last year. We don't need to make any changes. Okay, let me just run through the checklist. And, out of the 30 things, there were 3 things on there that they're like, oh my gosh, yeah, I forgot we did open that new bank account. Oh my gosh, I forgot we did do that. Oh yes, I forgot I didn't even know that affected it. So that's what you're going to learn today. What are those things and how to do this? Okay. First, if you get married, you need to update your plan, period. You've got to update your plan. The law has imposed a whole new structure around your life. So if you get married, or if any of the beneficiaries or trustees or power of attorneys, any of them get married, okay, that changes the dynamic of how your plan is going to work. If something happens to you and you have in your document, I leave everything to, my kids, and then you get married and you didn't update your plan, it's going to be a mess. It's going to be a giant mess. So, they're going to end up in court. Even if they all agree, they have to end up in court to fix that legal document after you're gone. That's going to be expensive and messy. You don't want that. So if you get married, if any of your kids get married, here's why. Because when they get married, all of a sudden now their spouse has a community property interest, has a claim on their inheritance. Yes, inheritance is separate property, but trust me, it always gets commingled because they don't know how to keep it perfectly separate property. If they ever get divorced, their attorney is going to be able to make arguments around that and potentially cause a nightmare, even if they, it's just going to be a nightmare. So if there's any marriages, make sure you come and ask, what do we need to change? On the flip side, if there's a divorce, or if the divorce is pending, in a couple of weeks, I've been invited to teach a CLE to divorce attorneys on how this affects each of their clients' estate plans. If a divorce or legal separation is pending, or if they have just physically separated, it affects a lot. You've got to think about this because in your married estate plan, by default, either everything goes to the surviving spouse, or if it's a blended family, it gets split in a really messy way. And so through the divorce, you want to make sure that that one doesn't pass away, or you don't pass away, and everything ends up in your soon to be ex-spouse's hands, right? It's like you're getting a divorce to separate your finances. Make sure your estate plan is up to date. Same thing with your children or your beneficiaries. If they have a pending divorce, you want to make sure that if you pass away, it goes to the party that you're intending. If there's an emergency with you, and doesn't end up in the soon to be ex-spouse's hands. Now, the fun piece is if there's any new babies. I think, it's been years since my wife have had a new baby around. And so, just the little feet on this picture, I just love. But if there are any new births in your family, either your own, you got new babies, or you have new grandkids, that's a potential need for a change. There's a bunch of factors for that. It could be because you want to include them. You want to set something up, for their one-day college. Or if they have special needs, God forbid. But if they do, that can require just an extra provision in there to make sure that they're taken care of, so they don't lose the benefits that are there to help them through their life. It could be that it was a grandchild born under a child of yours that you have actually no relationship with. Maybe you've disinherited that child, but they've had a child. The law doesn't automatically say that one is disinherited. Maybe you want them to be, maybe you don't want them to be. I'm just saying this affects your estate plan. Next is any big moves. So what do you mean big moves? Big moves from the perspective of your house. I mean, that's the biggest. Most people, that's one of their biggest assets. And it also affects just a ton of things. I was just doing a consultation with another attorney from the East Coast who there's an issue where somebody passed away and sustained some massive injuries. So there's a lawsuit pending around those injuries, but they died as a result of that. So their estate is now going to receive that settlement. Well, this person who passed away, they were a snowbird, partially in Arizona, partially back east. So it's like what state has jurisdiction over administering that estate? Well, unfortunately, they didn't do a will. So now there's going to be a potential fight between, not the beneficiaries, but between the state of Arizona Department of Revenue, the tax, and that state Department of Revenue back east. They might end up fighting over which state has jurisdiction to tax this settlement amount. It's crazy, right? If you move around or you're a snowbird between different states, your estate plan needs to declare which one has the jurisdiction over your estate. The state back east in this scenario will tax it way more than if it's an Arizona estate. So there's different states tax these things differently. So what if you're just moving within the state? You need to just ask the question. The biggest thing that happens is when you move out of one house and into another one, if you don't acquire that one and wrap it into your trust, then it's now going to end up in probate. And so that's an easy fix, but you just need to ask that question. Now, a tip is before you close on that new house, tell the title company, I have a trust and I want it owned by my trust when we close. They can do that. So that's just a tip for you real quick to be able to get that done. Adult children. I'm one of these adult children, right? I have parents who are in their 60s and 70s, and I'm a grown child and, professional, independent on my own, pretty responsible, I think. But if you have adult children, there's two things to consider here. The first one is leaving them an inheritance, even if they're responsible, I would think like me, I'm a responsible guy, is risky on a couple pieces, couple elements for you. The first element is it's risky because if I inherit any money and then something happens, I accidentally run into a car accident, or just something bad happens, or even a fake thing, something litigious, somebody just sues me, right? That inheritance is now subject to just going away into that lawsuit, them taking it all. The other thing is, I don't anticipate myself and my wife ever getting divorced. We are literally happier than ever. But if something were to happen, the divorce rate's over 50%. Something were to happen and your adult child gets a divorce, like I've said, that divorcing spouse can make a claim against their inheritance if it has been protected. So for adult children, even kids like me who are responsible adults, you can give it to them in a way that's protected and can never be lost to a third party on accident, to a lawsuit, to a divorce, nothing. So you can protect it. It's called a beneficiary protected trust. Now, the other thing that happens with adult children is not when they're my age, but when they're just turning 18, right? They just are becoming fresh adults. Now, all those same issues apply, right? You want to protect their inheritance from creditors, protect it from a divorcing spouse, that kind of a thing. The other issue is now that they're 18, they're a legal adult. And so what happens? Well, if you don't have protections in there from them getting just a pile of cash on their 18th birthday, they will get a pile of cash on their 18th birthday. And you know what? No matter how much my head feels screwed on right, which I think it was when I was 18, I was not trained. I was not experienced in handling any amount of money. We have numerous cases where there wasn't protections for that. One jumps out, one just comes to me because it was one of the worst examples. A guy in his 50s had a stroke and died just unexpectedly. He had two kids in their young 20s, nothing in place. State law says it goes to the kids 50-50, and outright, because they're over 18, had to go through a big ugly probate to finally get everything in their hands, because that's just how it works. And so finally write them the check, and the son completely just disappears off the radar. I mean, gone. We had to actually get some more documents signed by him as the course of the probate went on. Really hard to find him. And finally, after a couple of years, we did find him, and he had blown through hundreds of thousands of dollars of his inheritance. I mean, and just off the rails, partying, giving money. It just, anyway, you can protect that from happening. It doesn't only happen to 18-year-olds. Another one, just, oh, this kills me. It's almost laughable, some of these stories. Elderly lady passed away in her, I think, 80s, because the sons were in their like late 60s. So she must have been near 90. Anyway, she passes away. She has a pretty modest estate. She had lived really frugally, saved and scrimped, lived just on Social Security, had her, she had a mobile home, manufactured home, paid off, no debt on that. And she had one like IRA or annuity that was worth like $100,000. And so by the time the house was liquidated and the annuity was cashed in, each of them were going to get about $200,000. It's not, pocket money, but it's not millions of dollars. Well, the one we were working with, the one son, he got his check, and he came back for the last appointment to my office. And I remember walking out to meet with him, and I glanced out our front window where he was parked, and it was this big, beautiful, bright yellow, brand new Hummer, a brand new Hummer. And I'm like, whose car is that? And I walk in and sit down with him. And he said, do you see the new car? And I just was like, oh my gosh, I can't believe you did that. Your mom did not live this frugal life so that you could go buy a brand new Hummer after she died. But he did. And, about a year later, he was broke again. Big surprise. But she didn't really have any instructions or mechanism in place to help him learn some frugality, or at least if he doesn't want to learn the lesson, at least he's got some little bit of financial security for the rest of his life. So anyway, it's not just 18-year-olds, but adult children are an issue when they become adults or as they go through life. If you're not seeing that sort of financial savvy click into gear, then you just need to know this isn't happening. It's not changing for the better. I need to do something to protect them. Just like right now, you're not piling that money in their hands right now. Certainly, if somebody in your family has passed away, either obviously a spouse, then you definitely need to investigate whether a change needs to be made. A spouse, a child, or any of your trustees, somebody who's your healthcare decision maker. It can also impact your estate, your plan. If you've had a sibling die, or if you've had a parent die, those kinds of things don't feel like they automatically are part of our estate plan. But because those are the parties that have this extended right under Arizona's default laws of who has any rights to your estate, not rights to get it, but rights in a contingent mechanism, it's just a question. Hey, my sister died. Does that affect anything with my estate? And it might be a quick discussion, and the answer maybe is just no. But I've seen it happen where the answer is yes, and you don't want that to affect you. Obviously, if a parent passes away, it can affect you because you may be inheriting something, or you may be needing to disclaim an inheritance, saying, you know what, I don't need it. Can I just let it fall to the next generation? It can affect your estate, definitely. And there can be some tax strategies around doing that. And also, obviously, I think if your trustee passes away or your healthcare agent passes away, those people need to be replaced. You need to bump people up in order and make that update. When a spouse passes away, a lot of things do change, and most of it feels like it should be automatic. If it's set up really well, it kind of is, but there's always something that has to be done. Somebody you got to notify, the bank, your financial advisor, your tax person. There's definite paperwork that has to be done. And if it was set up well and you've kept things up to date, then yeah, it's going to be simple. But we've seen plenty of times where a spouse has passed away, they didn't have things organized in an organized way, and the surviving spouse has to go through probate. We had one where it was really sad. The husband and wife had actually called us, scheduled an appointment to come in to get their estate organized. It was a couple weeks away, and he passed away before their appointment. He died, so they never got anything done, and she had to go through a really messy probate because the way they had lived, they had been married 50, 60 years. He had made the investments, managed the sort of big picture financial things, and so lots of the variety of things they had were in his name alone. She didn't know where they were invested. And so a lot of it was just digging and learning and waiting for some mail to show up and thinking we were done. And then some new thing would show up and be like, we have an account out where? And then, more probate work. So it can happen between surviving spouses and when one passes away. And even if you do have a trust with your spouse, there's been so many changes in the trust laws over the last 5 or 10 years that if you haven't gone through a big update in that time period and your spouse has passed away, you need to ask the question of, what do I need to do? Because there were some strategies that were put into trusts for married couples back in history 5-10 years or more ago, that if you now have a spouse that's passed away, your trust from 5 or 10 years ago, it might require you to do some things to make those tax strategies effective. And if you haven't done it, even if your spouse passed 3 or 5 years ago, you might need to do that now to preserve some of those protections. So death just does have a lot of impact on needing to update your estate. If your dependents have changed, this might this might affect you in two ways. You've either had more kids yourself, if you are still in that phase of life. You know, a good estate planner will say new kids are automatically included equally with all the other kids. Great. But if you've had a adult child who has had more kids, same kind of instruction should be in there from your prior plan, but you probably want to ask the question, do I need to specifically name them? It just can be critical. The other thing is, I mentioned earlier, is if one of those kids becomes disabled or has special needs, sometimes that develops older in life, and either it can develop as a a young adult, a teenager. Sometimes it might develop in their 20s. We have a number of clients where a mental health disease didn't develop really until they were 20, 21, 22, and then it hit, and there's no going back. It's never going to be the same. So you just need to evaluate, is that something that's affecting my estate plan? The piece of it where you should look at your kids or at your grandkids is the same thing, because if they've had a child who has developed any of those disabilities or special needs, then you want to ask the question. There are so many good programs and benefits that can be given to those to people who are disabled. You don't want your inheritance on accident. You pass away, lumps into their lap, and then disqualifies them from everything. You don't want that happening. You want to add those protections to your plan. If you purchased anything big, this is always a trigger. Either a new house, definitely, right? Does this affect my estate plan? The answer is yeah. We just need to make sure it's part of it. Maybe you did. If you buy that house, make sure you tell them, okay, please buy this in the name of my trust, not, just with, community property with you and your spouse in your trust. Or if you've, we see a lot of clients right now, the stock market is kind of just like going bananas. So not as many people are doing it, but some people will take a chunk of their retirement savings and put it into an annuity, some type of fixed income. It's got some guaranteed interest kind of a thing. If you do that, great. I hope that fits for you. You need to ask, does this new account affect my estate plan differently? Probably yes. Okay. You just want to ask that question. Or you've bought a new life insurance policy. Maybe you've got a new term policy or a new policy that has some cash value in it. There's some policies that people we see are getting that have like a long-term care benefit on them. And so you maybe have it for that purpose, great. Let's, just ask the question, hey, this is what I had before. I did this now. How does that affect my estate plan? Or you purchased a business maybe. That can definitely affect your estate plan. How's that going to transition? God forbid something happens to you. Do we need to wind it up? Do we need to sell it to somebody? What do we need to do? Any valuation changes? There's been a lot of movement in the market. Real estate's going bananas, stock market's going up. And so I generally say, if there's been like a 10% change in your overall net worth, it's worth the question of, hey, does this affect anything? The value of your assets affects two things. It affects the default rules of our probate system, whether they can grab your assets. The second thing is all of the tax laws. A lot of them are based on value. And so if you were here and now you're here, well, it might be a whole new tax scheme that affects you. And you don't want to blow a bunch of money on taxes. I think we've all given more than enough to the government in taxes. This one is really if you want to make a change, right? You may not have had like this external event happen in your life, but if you just, maybe somebody has moved, or you developed a closer relationship, or your relationship has distanced a little bit with your trustee and you need to just make a change. Yeah, you need to make a change, right? This is kind of a simple one. The way our clients do it is, hey, I need to change who my trustee is. We say, great, tell us about the change. Sounds good. Come in next Tuesday and we'll sign the document. It's simple once you've already set it up, but it might need to change because they've the relationship dynamic has changed either for the better or for the worse. Or maybe they have just said, you know what, I'm just not in a place in life where I can take that on. Maybe they've just told you, like, please, find somebody else. You need to find somebody else. Or they've had something happen in their life that's just a bad idea. We have one that we're working on right now, protecting. She had this one child named, but that child has been sued in the course of some business arrangements that she has. And so it's like, yeah, let's just not put this on her plate right now. Let's move it to another child. So something might happen in their life. Just any of those things might happen. You want to make sure you say, hey, I might need to make a change to my trustee. It's simple from your perspective to name that next person. When somebody calls and says, hey, can we do it? There's a lot of background that we have to do. It usually requires a change in about 6 or 7 of the different documents, but we make it about as simple as can be. Or if you're a business owner, right? You're a real estate investor, you have multiple properties, you've got, things going. Maybe you own a bar, maybe you own an architecture firm, maybe you've got a landscaping company, maybe you are a CPA and you got to practice, maybe you're a physician, whatever it is. If your business has changed on a few different aspects, if the value has gone up, definitely, because the IRS will love to hit that thing with taxes at your death. And guess who gets to determine the value of it? The IRS does. So we want to make sure that the value of that is appropriately coordinated in your estate plan, and then saving those estate taxes as much as possible. So on the tax side, if the value has changed. On the ownership side, if you have added a partner, if a partner has left, if you're bringing in outside investors, if you want to sell, or maybe you've bought and acquired a business or something like that, any of those things, all of that is going to affect your estate plan in some way. Imagine if poof, right? If that car accident I told you about at the beginning, imagine if that was you and nobody has instructions from you on what to do. Your verbal instructions don't matter, right? We're talking about the law here. If it's not in writing, it doesn't exist. And if you throw it down in writing, who knows if that's going to stand up in court. It's going to have to go to court, and then it's going to be a fight. You want your wishes to be in legal form, so that, what we do when somebody tries to challenge one of our clients' plans, it's kind of fun because it doesn't happen that often, but if some disgruntled beneficiary or, bankruptcy court or some, lawyer sends us a demand letter threatening blah, 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 we have this process where we put this letter, nice cover letter with the copies of the appropriate documents, we send it off to them. And we say, sure, go ahead and do what you are threatening to do. And here's all the consequences that are going to happen if you do that. And so far, every single time we've had the chance to send that letter, we have 100% success in those threatening people. Never hear from them again. It's a ton of fun. That's what you want. That's what your family, your loved ones want. They want the certainty to know that's the kind of gift you left them, right? Few other things, you might think about this from also the perspective of if there's been a major medical change with you, your spouse, your kids, just any major medical change. If you've had a change in your coverage of long-term care insurance, because there are some strategies that can help protect your estate from those nursing home costs. If you guys have received a large inheritance or a large gift, you want to wrap that into the plan and make sure there's not going to be excess taxes on that. And then the big one that I could spend a whole, day talking about is the proposed changes in the law. Now, we do track all the changes that affect trust laws, probate laws, and tax laws primarily. Those exist at the state and the federal level. And then we also have to track the case law, right? The judicial decisions, right? That case law that comes out from the state of Arizona and from the federal court system. So we track all of that. There have been some changes in the last year or two that are big, and we've had to change our clients' documents. But the one that's pending right now, there's a proposal draft bill in the House, in the Senate, and the White House has a version. All three of those proposals agree to increasing the estate taxes. And the way that works is right now we all have, the current law says you can leave $11.7 million to anybody you want and pay zero estate taxes. It's only the dollars above that that would pay estate taxes. The proposals that exist right now would take that free $11.7 million amount and reduce it to $3.5 million. So then everything over 3.5 is going to pay estate taxes. And the tax rate proposals are anywhere from 40 to 50 to 55% of that amount. So if you're under that, you know, you don't have to worry about it. But if you're over that, even by $100,000, that $100,000 is going to be taxed at least at 40%. $40,000. If you're over that by $1 million, $400,000 in estate taxes. So this pending tax change at the federal level, we're watching it. We all kind of expect it to be passed sometime this year. We hope that the effective date will be next year and not retroactive. There's some pundits saying, no, they're going to make it retroactive. I will pull the rest of my hair out if it does. But so just so you know, this is a big one. If this change happens, we're going to be coming like screaming our heads off for all of our clients who are who are over that dollar range to update their plan. Because I believe we've paid enough taxes already during our lifetime that we should, and you can, it's pretty simple. The strategies to avoid the estate tax are not that complicated. They're very well, established strategies. We just have to do them. So we'll let you know, but that's a legal thing, right? If the laws change, you need to ask, does this affect my estate plan? The big one just a year and a half ago was the Secure Act on how your IRAs and retirement accounts are taxed. Big change. Affects your beneficiaries hugely. So anyway, this stuff just happens. You have to watch for it. You have to make sure your estate plan coordinates with all that stuff. It's supposed to take care of the taxes, the asset protection, and avoiding probate, right? It's supposed to take care of all of that. Whew. Okay, catch my breath. I have a few minutes built in right here to pause and take questions, which I'm going to do the best way for me to do it so it's not just a hard free-for-all, is for you guys to put them in the chat box. I haven't seen any questions pop up while I've been going, so I'm going to pause for a second, take a drink, but you guys find the little chat feature here on Zoom and feel free to type any question, and I will get through as many as I can. I have one or two more things to make sure to go over before we finish. I want to let you guys know how to schedule an appointment if you need help with this, and give you the method to do that. It's a really nice, simple way to do that for you guys on this webinar today. So I'm getting a drink. You can see my U of A colors. Although I did go to ASU for law school, so I get to be on both sides of it. I don't see any questions coming in. You guys, I must have answered everything possible out there. And if I didn't, that means you guys know all the answers. You guys can teach the next class. Good job. I'm just kidding. So let me start into what do you do next? Made lots of notes. Good. We'll keep, I'm gonna move ahead. If you do have questions, drop them in. I'll watch there for just a minute. Your first step is to schedule an appointment. Dawn has a question. Okay, good. A couple questions coming in. Good. Let's see here. Dawn asks, is there a fee to change the executor? Is there a fee to change it? So I guess you're asking, is there a fee for us to do that and make that change? So our firm has a couple different ways we work to make amendments. It's all based on if you already are a client of ours. And so I'm going to answer it from that perspective. If you're already a client of ours from the past, then the way to make a change is to call the office. Call the office. The phone number is 480-209-6942. Call the office and say, I need to make a change. And then the office will guide you through that process. We have two fee structures for that. One is just an a la carte. The office will tell you about that. It might be, $400, $500, $600, just depending. Like I said, an executor change could affect like 5 or 6 different documents. If you're on our annual maintenance program, then there's no change, and it'll just be part of your annual program. If you're not yet a client and you want to make a change to documents you already have, then you'll do this: schedule a free appointment, and you can go to this website. It's bit.ly, it's bit.ly KLF appointment, and you'll capitalize those letters. And I just dropped that into the chat box. And you'll just schedule your first free appointment. The thing that is really important is that sometimes making a small change that you need to know about is it is a lot easier and simpler. Again, if you're not a client of ours, it's a lot easier and simpler for you to go back to whoever drafted that stuff you already have, because they've already got you in the file and the system. They can probably, however they make changes, it's a lot simpler for them to do it. When somebody comes to us for the first time, we have to bring you up under our system. And so there's an investment again to do that. And so if you can go back to your old firm, it's sometimes just a lot simpler for them and less expensive for them to make that change. If you're interested in investigating what that would look like to come up under our law firm, that's what you do. You go to bit.ly, bit.ly/capital K, capital L, capital F, Keystone Law Firm, capital A for appointment. And then on there, I'll just give you options for a quick free intro call. And we'll go through and talk about what might need to be done and what it would look like to get started. Next question. Do you have updates for the masterclass to incorporate these updates? So for everybody who doesn't know what our masterclass is, last year during the pandemic, we were just getting lots and lots of people who were like, I need to get this done. I need to get this done. And it was more people than we could ever hope to serve. And we had a big chunk of them who were like, I need something quick and affordable. Like I'm not ready to spend thousands of dollars here. So we put together something we call our Family Living Trust Masterclass Kit. I've been wanting to do that for years because I have a passionate distaste for the way LegalZoom does things. It just and a lot of the other document prep services online. So we essentially created our own online program for you to get it done. What it does, that's what our master class is. What it does is it gives you the documents. You get the documents. You get instructions, toolkits. You get like toolkits that I've created, and I know where people run into most of their problems when they're doing this. But then you get modules, video training modules like this one, but specifically, what do you do at each next step of the way? And how do you do this on your own? I think there's 8 modules that train you on all of this stuff: how to fill the documents out, how to make the decisions, how to blah, 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 blah. That's a $297 kit. It's $297 and it's all there. So are there updates to that masterclass to incorporate these updates? We don't have tax law updates in there yet because the tax law changes haven't passed yet. To incorporate all these other updates, it's a different process. You'll go through the masterclass again and just repeat the whole process. We haven't yet built out a new masterclass for updating your previous masterclass. So you would essentially just kind of go through the whole thing again. Feel free, ELN, feel free to send an email to that masterclass support email that you should have to get some more instructions on that specifically. Larry asks, how can old POAs still be valid? Old POAs still be valid, I think is what you're asking, Larry. The challenge with old documents is not so much whether the law says they're still valid. It's whether or not your banks, your financial institutions, your advisor, and anybody else that might need to do business for you on your behalf, it's whether or not all of them are going to recognize it as valid. there's a gal who, this is the first time I ever experienced this, their power of attorney, their whole estate plan that they had a friend draft up, will, trust, everything. Their own estate plan, their own financial advisor's office rejected the power of attorney because it was too old. And that was my first experience. That was, 12 years ago or something like that. Because they said it was too old, they froze the account. Her husband had dementia. They froze the account. She couldn't get any money out of it. And they said, we'll give it to you. You just have to go get a court order saying you're the conservator. She didn't know what that was. Her financial advisor didn't know what that was, referred her to me to figure it out. It's the probate system to give her the court order that says you can now access this account. That ended up costing that family like $40-some thousand to get that first court order. Then it's an annual like $5,000 to keep the court order renewed. Super ridiculous expensive, because the power of attorney was said to be too old by some bank. Well, how old is too old? That's where we have just discovered. We've just said, you know what? We're going to check in with our clients once a year. So far, when we do that and we sort of sign off and go, yep, this is good, we haven't had any clients of ours run into that problem. I know some people say 3 years. I'm not comfortable with that, because I've seen clients run into problems when they are less than 3 years old. Banks are just finicky out there. And when you've got somebody standing behind it, like our law firm or any law firm, I think, then your family has a shot at success. And so I've just seen, when it's a year, we can literally send that bank and get to their legal department and say, no, our legal opinion is this is valid and you need to honor it. And then it avoids us having to go to court to prove it to anybody. We don't want to have to do that. So it's a matter of keeping it up to date and making sure it doesn't get that old in the first place. Okay. And so, when we do that, also, we sort of just wrap in all of the new boilerplate, the new language that goes in there. That's part of the important reason to work with someone who does this a lot. It's because we do tweak and modify all that boring legalese that's tucked in there, because it does sort of morph and mesh over time. I don't see any more questions. So your guys' next step, jump on that website, bit.ly/KLF appointment. The link is in the chat box, and I'd love to meet with one of you, all of you, to help investigate what you need to do next for your family. All right. That is all I had. It was a pleasure to be with you guys today. Go out there, make a difference for your family. Remember, we don't have a guarantee for tomorrow. Today, right? We got to do things today that are important. All right, everybody, my best to you all.